Melania Trump's legal catastrophe. Okay, I need you to stay with me here, because what I'm about to walk you through is something we almost never see in American legal history. The First Lady of the United States is about to be forced to testify under oath about her marriage, her living arrangements, her tax filings, and her connections to Jeffrey Epstein. And here's the thing that makes this genuinely unprecedented. She did this to herself. Her own legal team made a catastrophic miscalculation, and now there is no way out. This isn't speculation. This isn't anonymous sourcing. This is happening right now in federal court, and the implications are staggering. Let me tell you exactly how Melania Trump walked into a trap of her own making, and why even a Trump-appointed judge probably cannot save her from what comes next. Here's what you need to understand about how we got here, because the context matters enormously. Back in October, veteran journalist Michael Wolff received a letter. Now, if you followed the Trump family for any length of time, you know exactly what kind of letter this was. It was a demand letter threatening $1 billion defamation lawsuit. That's billion with a B. The letter came from Alejandro Brito, a Coral Gables attorney, who has become Donald Trump's go-to legal attack dog for silencing critics. And the substance of that letter was essentially this: apologize. Retract everything you've written about Melania Trump's connections to Jeffrey Epstein, or face complete financial destruction in court. Now, most people who receive one of these letters from the Trump legal machine do one of two things. They either comply immediately, issuing what Wolff himself described as North Korean style confessions and apologies, or they go silent and pray the whole thing just goes away. But Michael Wolff is not most people. Subscribe to this channel right now and turn on notifications, because what happens next in this case is going to reshape how we understand accountability. For the most powerful people in America, Wolff is a veteran investigative journalist. He's written multiple best-selling books about the inner workings of the Trump White House. He spent years documenting the chaos, the dysfunction, and the secrets that the Trump family desperately wants buried. And when he received that billion-dollar threat, he did something that nobody expected. He sued first. Think about what that means for a moment. Instead of cowering, instead of apologizing, instead of going silent, Michael Wolff ran straight to New York State Supreme Court and filed a preemptive lawsuit against Melania Trump. In that filing, he laid out every single statement her lawyers claimed was defamatory, and he explained in methodical, devastating detail why each one was either demonstrably true, fair and accurate reporting, constitutionally protected opinion, or taken completely out of context by her legal team. But here's where it gets genuinely fascinating. Wolff didn't just defend himself. He went on offense. He called the Trump legal strategy exactly what it is: a pattern of strategic lawsuits against public participation. In legal circles, these are known as slap suits. Lawsuits filed not to win, but to intimidate critics into silence, to drain their resources through endless legal battles, and to create what Wolff described as a climate of fear, so that Americans cannot freely exercise their First Amendment rights. Stay with me here, because this is where Melania Trump made the biggest mistake of her life. Her legal team, rather than fighting in New York State court where Wolff had filed, decided to try something clever. They filed what's called a notice of removal, attempting to move the entire case to federal court. Now, on the surface, this might seem like reasonable legal strategy to federal court. Federal court has different procedures, different rules of evidence, and in many cases, defendants prefer federal judges to state court juries. And in a stroke of what can only be described as Trump luck, the random selection process assigned this case to Judge Mary Kay Viscoso. She's a Trump-appointed federal judge in Manhattan. This is the same judge who ruled against Manhattan prosecutor Alvin Bragg when he tried to quash a congressional subpoena. The same judge who denied Columbia University's attempt to challenge Trump administration funding cuts. So Melania got her Trump judge. She got her federal court. Everything should be going according to plan. But here's what most people completely miss about federal jurisdiction. And this distinction matters enormously. To remove a case from state court to federal court, you need a legal basis for federal jurisdiction. The most common basis is something called diversity jurisdiction. What this means in practice is that the two parties in the lawsuit must be citizens. If both parties are from the same state, there's no diversity and the case stays in state court. Michael Wolff is from New York. That's not in dispute. So, for Melania Trump to move this case to federal court, she has to establish that. She is not a resident of New York. She has to prove that she's a citizen of a different state, presumably Florida, where the Trump family claims official residence. And this is where the trap snaps shut, because now, under established federal procedure, Michael Wolff's attorneys have the absolute right to conduct what's called limited jurisdictional discovery. Let me say that again so it lands properly. Melania Trump's own legal strategy has now given opposing counsel has the right to depose her, to send her written interrogatories, to subpoena her financial records, to demand her tax returns, to ask her about every single aspect of her life that relates to one fundamental question. Where does Melania Trump actually live? If you're finding this breakdown valuable, hit that like button right now. And I want to make sure you understand every dimension of it. Think about all the questions Melania will now have to answer under oath. Where does she sleep most nights? How many nights per year does she spend at Mar-a-Lago versus Trump Tower on Fifth Avenue versus the White House? When did she last spend the night in the same bedroom as her husband? What do her tax returns say about her state of residence? Has she claimed Florida residency for tax purposes while actually living in New York? What about property tax exemptions? The homestead exemption in Florida is substantial, but you have to actually reside there to claim it legally. And then there's the Barron Trump question. Barron Trump is currently a student at NYU New York University, located on Fifth Avenue in Manhattan. Now, NYU charges different tuition rates depending on whether you're an in-state or out-of-state student. The difference is substantial. So what did the Trump family claim on Barron's application materials? Did they claim New York residency to get in-state tuition benefits? If they did, that would directly contradict Melania's claim to be a Florida resident for jurisdictional purposes. Here's where it gets even more revealing. There has been substantial reporting over the years about the living arrangements within the Trump marriage. Multiple sources have indicated that Donald and Melania don't share a bedroom. Reports have consistently suggested that Melania spent very little time at the White House during Trump's first term. She was seen far more frequently in New York City, maintaining her lifestyle on Fifth Avenue, shopping, attending spa appointments, having lunch with friends. During the second term, her absence has been even more pronounced. She's essentially invisible at official White House functions, except for the occasional state dinner. The reporting suggests that Melania Trump lives primarily in New York City to maintain proximity to her son at NYU. She's not shopping on Worth Avenue and Palm Beach every day. She's living her life in Manhattan. And now she has to answer questions about all of it under penalty of perjury. Some might argue that Judge Viscotial could simply limit the scope of discovery to protect Melania. After all, she's a Trump-appointed judge with a clear track record. But here's the fundamental problem with that theory. Jurisdictional questions are not discretionary matters, where a judge can side with whoever they prefer. The rules of federal procedure are explicit. If there's a legitimate dispute about diversity jurisdiction, the party seeking a federal court has to prove their case, and the opposing party has the absolute right to challenge that proof through discovery. Even a judge who desperately wants to help Melania and Trump has to follow the law. And the law says that if Wolff's attorneys can articulate a good faith basis for questioning her residency claims, they're entitled to discovery on that issue. Given everything that's been publicly reported about Melania's living arrangements, there's clearly a good faith basis for that challenge. Now, let's talk about the substance of what Wolff actually wrote. Because when you examine, Melania's lawyers claimed the statements were defamatory, causing damage to her reputation. You realize just how weak her position actually is. Statement 1, that Melania Trump was very involved in the Epstein situation. Michael Wolff says this was not defamation, but journalism. He argues his statements about Melania Trump were taken out of context and are either factually true or protected opinion. He never claimed Melania spoke publicly, only that she acted behind the scenes. He also reported her possible link to Trump's Epstein connections based on documented facts. Melania's modeling career with ID models, her meeting with Trump at an agency party, and the involvement of figures connected to both Trump and Epstein are all part of the public record. Wolff also says Epstein himself made claims about Trump and Melania's relationship. The bigger issue is Melania's legal strategy. By moving the case to federal court, her team triggered jurisdictional discovery, forcing potential testimony under oath about her residency, marriage, finances, and taxes. The defamation case looks weak, but the exposure is massive. The most likely outcome is a deposition that puts deeply. It's about accountability, and once discovery begins, there's no controlling what comes out.